So finally, we're getting to same-sex marriage and the role of the courts in a democracy, and why the recent same-sex marriage case, Obergefell versus Hodges, is important for the general study of politics and what it can teach an intro course in terms of political science beyond simply the case itself. Just as a review, I want to make sure that we understand the general role of courts in the government from the prior presentation. The primary role of courts is to enforce the laws when there's a conflict between someone's individual behavior and the statutes on hand. This is particularly true in criminal cases. The other role of the courts, perhaps more common in some ways, is to adjudicate a conflict, and that's essentially a conflict between two private parties who believe that one of them believes they've been mistreated and they need a referee, or between an individual or a group and the state, meaning government. And so, enforcing laws, adjudicating conflicts, they also, as I mentioned in that last presentation, they interpret the meaning of a constitution and the various laws or policies or decisions when there's a disagreement between again, the aggrieved party or an alleged aggrieved party and the action that was taken. And it's up to the courts to interpret who's right and why. And in doing so, they set sort of constitutional precedent and develop what's called doctrine. Then finally, that's the final sort of purpose of a court, is to have consistency and coherence in the doctrine on issues, hopefully as a guide for future cases or future conflicts. Sometimes that works, sometimes it often doesn't. So we're going to look at the U.S. in the case because, of course, this is a case in U.S. constitutional law. But to do that, I want to make sure everybody understands sort of what the Supreme Court does in the United States. The Supreme Court has the sort of the role in our government that we call judicial review. And that basically means that the court gets to review challenges to statutes to determine whether or not an action was constitutional or not. And in terms of, well, okay, how do they do that? By the way, that was established in 1803 in Marbury versus Madison, where the Justice Marshall had the famous sort of decision where he said, look, it's our job to interpret what the meaning of the Constitution is. And so that set up this idea of judicial review, and the court has had that power ever since. So now, even though they have that power, they can't go out and just sort of issue edicts. They're reactive. The Supreme Court, often called the least dangerous branch of government, is reactive, meaning they have to wait for cases to come to them. However, in the modern period particularly, interest groups, individuals, political parties, groups that are trying to promote a particular cause often go hunting. They're very active. It's a strategy of interest groups to sort of lobby through filing court cases. And the way they do that is they go and they find ideal cases that might be good tests, where there's an important unanswered constitutional question involved, or an answered question that may or may not need to be revisited. Nearly all of the cases that the Supreme Court deals with are on appeal. And in order for a case to be heard, four justices, called the Rule of Four, have to say, yeah, this is a case with a substantial constitutional question that we should hear. And if four of them out of nine say that they want to hear it, a writ of certiorari is granted. And that means they hold a hearing, they put it on the calendar, they solicit briefs, they allow sort of people who aren't directly involved to file what are called amicus briefs. And so there are a whole bunch of, a brief, by the way, is sort of the legal argument for why the court should decide the case in the manner consistent with what the group writing the brief wants. And so, often there are scores of briefs. You have the primary briefs written by the parties that are directly involved, and then you have interested parties filing amicus briefs. Once those are filed, there are oral arguments. They usually take place from October through February, March, sometimes as late as April. And the oral argument is essentially each side gets 30 minutes, and sometimes they extend that. And they listen to the case where the Supreme Court can pepper them with questions or try to sort of seek to help the side that they actually are on by leading them through an argument. The oral arguments are the big drama. Of course, we can hear them now, but we can't see them. Cameras are prohibited in the court, in the Supreme Court. Once the arguments are made, there's something called a judicial conference where the justices get together and they essentially argue out the case and decide, you know, what their vote is, and then eventually they do vote, and they have to write the opinion. The opinion of the largest number of people becomes what's called the opinion of the court, often called the majority opinion. Those who may agree with that opinion, but for different reasons, right? Concurring opinions. Sometimes you'll get people who say, well, I agree with some of it, but not all of it, and that's concurring in part, dissenting in another. And then finally, you've gotten the last one, which is the dissenting opinion. Dissenting opinion is written by the people who lose the argument. However, they're also often the most interesting because they can be vitriolic since they don't have a full force of law. They can, in addition, provide a little bit of support for a future argument to be made. So again, I just want to make sure that you guys know how to go through this. Now, before we go on to the case at hand, I have a few more things I have to do. And the first one is to talk a little bit about why same-sex marriage is an issue at all that the Supreme Court has determined on one side or the other for, the past 30 years or so. First is that state laws in the United States tend to be the laws where the presumed police powers reside. Police powers is a term given to all of those sort of day-to-day rules for governance, criminal law, civil law, the policies that states have are focused on we as citizens of that state on a day-to-day basis. Traditionally, these sorts of powers, including marriage, there's no federal marriage procedure requirements, although there is now a federal marriage requirement. But again, it's not a national policy. These are individual state policies because states have had historically and still today the police powers. The Civil War amendments, so-called Civil War amendments, 13th, 14th, and 15th, passed in the aftermath of the Civil War, and the decision finally that we made through a lot of bloodshed and killing of each other, it basically said we are one nation first rather than a bunch of states loosely tied together. And the 13th, 14th, and 15th amendments sort of addressed those. And they said, look, you can't deny the right to vote for black men. You can't deny sort of life, liberty, or property without due process of law. You have to provide equal protection of the laws, meaning you can't treat one group differently than another, and that each individual is sort of afforded fundamental liberty. So the Civil War amendments sort of created, particularly the 14th Amendment, which allowed sort of the federal government to enter into ruling on the constitutionality of state policies. The Civil War amendments opened up the door because it said, look, we are one country. We are not separate entities, even though we have 50 separate state laws now. That doesn't mean we're all that different. So the national government is supreme. And it's, 13th, 14th, and 15th took care of that. Well, in the 20th century, the Bill of Rights, which had originally only applied to the national government, not to state government, so the right of free expression, the right of the prohibition against establishing a national religion, the rights against search and seizure, the Second Amendment, these were all sort of focused only on the national government, not on state governments. But in the 20th century, something has happened that we call incorporation. And that basically means because of the 14th Amendment, the three provisions listed there, due process clause, the equal protection clause, and fundamental liberty mentioned in there, state laws have to sort of conform to those expectations as well. And so for issues of free speech now, or for rights of the accused, you get stopped in a car, there are constitutional doctrines that govern the way the police are supposed to behave. They often violate it, because if they can get away with it, they're going to get away with it. But again, if you ever get stopped in your car, don't give permission, and don't let them search, and remind them that you have not consented, and that they better understand they're conducting an illegal search if they don't have probable cause. Not that I want to get you to misbehave and get away with it. But again, the incorporation, selective incorporation of the Bill of Rights through the 14th Amendment, due process, equal protection, and fundamental liberty clauses, essentially give us national rights even when it relates to state law. One of the four big civil liberties that we have, you have speech, and you have religion, and you have speech and assembly. That's one. Rights of the accused, meaning we're treated all fairly when we come in contact with the law. And then finally, privacy. Privacy governs several things, but primarily contraception, the right to actually use and know about and educate about contraceptives. Made legal in this country in the 1960s, Griswold versus Connecticut, established the right of privacy, which was then used in Roe versus Wade in subsequent cases to sort of say that abortion relates to a privacy interest of the pregnant woman. Also, homosexuality, which is the case here, and then the right to die, the right for people to determine the conditions under which they can cease living on Earth. The extent to which these are sort of codified and guaranteed and universal vary. Privacy is the weakest of the four civil liberties in terms of protections, but it's an increasingly important one, increasingly interesting one, increasingly controversial one. So that's the topic of this particular presentation. So the issues at hand in this case is essentially the differential treatment of marriage at the state level. So marriage can be defined by the state. Several states, many states, it used to be all states, now it's a majority of states, treat marriage differently depending on who's getting married. And relates to the question of whether marriage is a civil concept or something that transcends simply a public understanding of a bond between two people. And so marriage can be seen as a sacrament, as it is in Roman Catholicism and other faith traditions. And so, that's one of the big questions. Can you treat people differently if there's a religious foundation or if there's a legal one? And it's a very important question. The second sort of aspect of differential treatment is, do states have any right to pass laws treating marriages differently based upon sex? Remember, the Equal Protection Clause says if you treat one group one way, you have to treat the other group the same way. And if you allow a man and a woman to get married, why can't a woman and a woman, or a man and a man, also get married? So you're treating groups differently. They are often called classifications or classes. And so, sexual preference or sexual identity or sexual behavior, it's really an identity more than a behavior, because one act does not make an identity. But anyway, the point is that treating same-sex couples differently exists in these laws, and the law that I'm going to talk about in a minute. So this is the real question. Do states have a right to distinguish between same-sex and opposite-sex couples? Also, does a state have to acknowledge the marriage of a same-sex couple who's married in another state? That's the other major question here. So if you get married and you're, opposite-sex couple in Maryland, and you move or you live in Ohio now, does Ohio have an obligation to recognize that marriage? The answer is yes. And the primary reason is there's something called the full faith and credit clause in the Constitution, which basically says that each state must obey or recognize the legal designations that were granted in a different state so that people could move without having too much disruption. And so the full faith and credit clause allow opposite sex couples to have their marriage recognized in the eyes of a different state from where they were married. And the question again is, can a state say we'll allow those, but not for same sex? This all comes in part from a movement in the early 1990s that culminated in 1996, and that's where I'm going next. A little more background. The Defense of Marriage Act. The Defense of Marriage Act, which is a public law, which means it was passed by Congress, which means it's a national law. PL 104, Public Law 104, 104th Congress, and Dash 199, that's the 199th law that was passed in that Congress. Each Congress is 2 years. So again, Defense of Marriage Act, DOMA is it's often called, has three very brief sections. The important operative one is Section 3. And I put a quote there basically that is directly from the legislation. And says, basically, the word marriage means only a legal union between one man and one woman, and the word spouse refers to only a person of the opposite sex who is a husband or a wife. So it's basically saying we're defining marriage in a very narrow way. So if states want to, they can actually ban people who don't fit that classification, meaning same-sex couples. And so, the interesting thing about this is not simply a symbolic thing. The types of benefits on the national level that are accrued to spouses are enormous. Social Security survivors benefits. So for example, if a spouse dies and they had the higher income and their Social Security payout was higher, a spouse is allowed to take that payment instead of their own. And as a result, same-sex couples who were in that situation were unable to do it. Housing, food stamps, veteran benefits, all sort of, determined by family. Pensions for federal workers, taxes on your income, estate taxes, and we'll get to that, gifts, property sale taxes, all of these benefits due to federal employees, civilian and military. We're talking about lots and lots and lots of designations. One big example is sort of the inheritance tax for family farms. Family farm could be subject to the inheritance tax if they didn't recognize a same-sex marriage of same-sex couples who actually own these farms, which means tax would go up a lot. And so we're not talking about hypothetical stuff here. We're talking about real impact that the Defense of Marriage Act has, and that is it denies same-sex couples these sorts of benefits. Section 2 of the Act is basically simply states that states aren't required to recognize same-sex marriage. Well, this was challenged several times, and finally in the 2013 case, Windsor versus U.S., it declared Section 3 unconstitutional, using what's called the Fundamental Liberty Clause of the Fifth Amendment. Because the Defense of Marriage Act was a national law, the Fifth Amendment, which is the Bill of Rights saying what Congress can't do, is to deny fundamental liberty. And they say, look, freedom, liberty, is stated in the Fifth Amendment as sort of being freedom, and you can't treat same-sex couples differently from opposite-sex couples. It just denies it. And so in the Windsor case, somebody who was subject to a much higher inheritance tax because her same-sex partner passed away and left an estate, if they were married, that person would have been exempt from that. And we're talking to the tune of millions of dollars. So this is not a small amount of chump change. The Supreme Court ruled in Windsor in 2013 the Defense of Marriage Act is essentially unconstitutional. That came around the time the tide was turning in terms of public sentiment, not not nationwide. We're kind of divided on this, although not as divided as most people think. But there was this evolving consensus. 40 years ago, same sex marriage was seen as appalling. By 2013, the country was sort of split on it, with people being ambivalent about it, but really not caring about it that much. So we have one more thing to do before we get to the case itself. I want to sort of talk a little bit about this issue of marriage and how the country that really codified the notion that church and state need to be segregated and separated through, and we created the Establishment Clause in the First Amendment to the Constitution, saying that Congress shall pass no law establishing a religion. Well, how do we get into this mess? And the answer comes from our history. This is why, remember when I showed you the systems diagram, it's important to understand the history and the development and sort of the political culture that we came from, because that explains a lot about why we're in this mess in the first place. The colonies had recognized and supported specific faith traditions, had several states had official state religions. Massachusetts, New Hampshire, Connecticut, they had the Congregational Church. New York, North Carolina, South Carolina, Virginia had the Anglican Church, or the Church of England, as it was sometimes called. And other states didn't have an official established religion, but it essentially enforced a certain morality, or, like in the case of Delaware, require that you be a Christian in order to serve in public office in any kind of way at all. And so, the colonies, before we became a country, had recognized and supported specific faith traditions using tax money often. In Virginia, by the way, if you didn't go to church on Sunday, you actually became, quote, a slave of the state for 1 week the first time, a slave of the state for 1 month the second time you didn't go to Sunday services, and then the third time you went for a year and a day as a slave of the state, meaning you go to prison and they make you do work detail, kind of like community service these days, when you get sentenced usually for a minor infraction or sometimes a significant infraction, but they don't want to send you to jail. So again, states propped up religion prior to the establishment of the Constitution. And the second reason is that the Bill of Rights, which came about as sort of the promised compromise in the constitutional debate, that really only applied to Congress. It didn't apply to these states. So these states, which had long traditions, maintained support and sometimes differential treatment all the way through as late as North Carolina in 1875. So a lot of states had sort of specific support of religion and religious groups sometimes well into the 1800s. So that's one of the reasons why we've had this mess, where even though we have the separation of church and state, our history and the Constitution, which applied to Congress initially, really didn't sort of make it easy for us to define marriage in civil terms. The other reason is we really didn't have a dual track idea of unions, as I'll call them, civil unions versus marriage, which took hold in Europe and is pretty common in places in Europe, and places like Turkey and much of Scandinavia, although not all of Scandinavia, much of continental Europe. They have a distinction between the civil union and the marriage. The civil union is the state's official recognition. That can be done through churches in most countries, or so there's an either or. It can be done through recognized civil authorities, usually a justice of the peace or a magistrate, or somebody who is designated in a local government building, who is the one who performs marriages. You can have a church wedding and a civil union in most countries. It's hard to do that in the United States. You can do it, and people do it all the time. And sometimes they wait to have the church wedding, and they have the civil union first. So we really never, because of our sort of distinctiveness and the decentralization of this issue, and each state having its own preferences, we really didn't develop this dual track idea that the state will recognize the civil union and the religious organization will recognize what we call the marriage, and that way the religious organization could provide the civil union while doing the marriage, but you need not have a marriage in the eyes of the law. So U.S. never had that, and that's why we got into this trouble. So here we go. Finally, we have Obergefell and John Arthur marry in 2013 in Maryland. Maryland recognized they allowed same-sex marriages. They lived in Ohio. So they went to Maryland, got married, moved back to Ohio. Ohio has a law that does not recognize, that specifically prohibits the recognition of same-sex marriage. Now, John Arthur had ALS and he knew it was terminal, and so the two of them sued to have Obergefell's name placed on the death certificate as a surviving spouse because they wanted, the estate to go to him, but they also wanted him to have legal family visitation rights, and that's not a given. Even in Rhode Island, a few years back, there was a case that was decided that allowed same-sex married couples to visit the other in the hospital when they're terminally ill the same way a spouse would because they had been denied. So anyway, Arthur had ALS. They wanted to have a death certificate with James Obergefell's name placed on the death certificate, and the county clerk was willing to do it, and the Ohio Attorney General Mike DeWine, who had also served in Congress prior to that, I believe he's probably going to run for governor when John Kasich, the current governor, is no longer there. He's the Attorney General, and he said, okay, fine, I'm not going to fight you on that, but the case went to U.S. federal court. And the federal court, in making a decision, overturned Ohio's law. As the Attorney General, DeWine has a responsibility for appealing if he thinks that he should defend the law, and he did think he should defend the law. And so he basically appealed it to the Sixth Circuit Federal Court of Appeals. The country is divided into a number of circuits, 9 plus the District of Columbia. And so the Sixth Circuit is where Ohio is in the Midwest, and goes to a 3-judge panel whenever there's an appeal. Their job is to see if there are any procedural errors that were made. They don't judge the content, but they decided in a 2-to-1 vote that the Ohio law banning same-sex marriage was indeed constitutional, and there was no federal violation here. And so on appeal, the decision was reversed, and Arthur's death certificate couldn't have Obergefell's name on it. That's why it was brought to the Supreme Court. And the case got consolidated and heard in November 2014. What I mean by consolidated is that it got joined up with 3 other cases into one. And that's where we have the Obergefell versus Hodges. Hodges is the State Department of Social Services director, and that became the name of the case that they heard. And of course, we know the decision, but let's go through it anyway. As you probably remember, it was a 5-4 decision. And the majority, Justice Kennedy writing the opinion, basically said, look, the 14th Amendment to the Constitution requires that states issue marriage licenses to same-sex couples because you can't treat them differently than opposite sex. They also determined that states have to recognize the same-sex marriages the same way they do opposite-sex marriages, which is required by the Constitution. And so it essentially finalized this question, and it said you can't, in a state, ban same-sex marriages if you have opposite-sex marriages, and you have to recognize other states' marriage certificates. So that was, we all know that decision. The interesting thing is the minority decision has a lot of different opinions in it, and there are a bunch that I want to go through. The first argument in the dissenting was that, we really should defer to legislatures whenever possible. And by overturning a legislative law, the court's overstepping its boundaries. The second minority viewpoint Debates in the political arena should govern such issues. Basically says the court is now a threat to American democracy because it short-circuited what is a wonderful, robust, lively debate that needed to continue to go on in order for the proper decision to be made. And so often it's related to the first topic, but it focuses on this idea that ongoing debates are good, not bad, so don't cut them short. The third, the court is creating a new entitlement that refutes the spirit of negative government. Basically says, look, the Declaration of Independence wanted us to be free. It didn't want us to grant rights to people. It simply wanted us to be free. And so by saying same-sex marriage now is required, it's essentially creating an entitlement for same-sex couples. And then the fourth major argument about why this was a bad decision is that, this is a Burkean argument. Traditions need to be preserved or changed through political channels, not the court. That you don't change unless you absolutely have to. Smacks a lot of Edmund Burke. Be interesting if you could right now figure out which of the four dissenting justices of Thomas, Alito, Roberts, and Scalia wrote which of these arguments as their focus. And actually, for those of you who are using this in your political autobiography, I'm going to ask you in the final stage to go and pick one of them that you want to pick. But let's not get into that now because we're already at half an hour and this is too long already. There's one more slide. So why is this case one that I would pick? Besides the fact that it's current, and I really wanted to sort of apply politics in this course to what's going on in the world right now, which is part of why the course isn't quite flowing as methodically as it could. But there are other reasons as well. The first is this case raises many different issues related to the concept of what is the proper form of democracy and what is the proper form of governments. What barriers should there be to the will of the majority? Is it really relevant that a majority of the people of the state of Ohio oppose same-sex marriage? Don't we have to protect minority interests? And when we talk about minority interests, we're not just talking about racial minorities or ethnic minorities or immigration minorities or economic minorities. We're also talking about social minorities. And so the question is, should the majority be able to sort of ride roughshod over a minority simply because there are more of them? That's a really fascinating question. The second is, what's the balance between state and national? We have the original Constitution, we had a very limited government, and we clearly don't have anywhere near that kind of government anymore. The national government is supreme, in part because we decided we were a union first in the Civil War, and we've been behaving that way ever since. And then the question is, well, how far is too far? But it raises this sort of proper balance of federalism. Should the states be able to outlaw same-sex marriage? And then what do you do when someone from a different state where it's okay to get married, moves into that state? And so it's a really fascinating question about sort of the layers of government too, and where the best locus of control might be. The third is, this idea of protecting minorities. It's a very important role in a proper functioning of a stable government. A lot of people who study democratization and states that work versus states that don't. Now I'm talking about countries, not about United States. They say, all right, one of the most important elements of a stable functioning democracy is minorities don't get abused. And so what is the proper level of protection of minorities? Very fascinating question. And then, the fourth question that I just put up there relating to government is, you have these justices who are appointed and they have life tenure and they're insulated from political sort of pressure, although there's certainly a lot of political pressure placed on them. What should they really be doing this? The next thing is the role of values in public policy. What is the role of a religious or a moral or a social value in the creation of public policy? That's a very important question about same-sex marriage. The implications for religious organizations. Should religions be able to sort of require that people who don't agree with their religious doctrine adopt or behave, in ways that are consistent with those values. And then if you say you shouldn't do that, well, are you trotting upon the religious freedom of these groups? One of the big concerns is that, all right, what happens when a religious college, not like PCs sort of embrace the idea of same-sex partnership and marriage in its non-discrimination policy. They did that a couple years ago. So PC is not likely to change much other than give benefits now to domestic spouses who are same-sex. We'll see if they do that. I don't know if they're going to do that. But anyway, there is concern that a more religious institution may be uncomfortable hiring someone. Is that going to be against the law? There is a concern about that. The other reason it's important is because it sort of is a great example of the dynamic reality of politics and why it's such a fascinating thing to study because it's always changing. That's what I mean by dynamic. Our system in the US is very Newtonian, but the world changes every minute. And that's why politics is so interesting to study. And this is a great example of that because, again, when I was your age, this whole idea was so foreign to anybody. Same-sex marriage, why are we talking about that? That's never going to happen in this country. Well, not that long ago. We also sort of look at stability versus change, sort of which is preferred, but also how you move from a stable system to one that changes without completely destroying a system. And, there's a real concern now among some people about, well, all right, well, how do we deal with marriage now if we have to treat same-sex marriages the same as opposite-sex marriages? The other reason is public sentiment. There's been an enormous shift. Your generation, those of you who are under 40, really doesn't get this, but your grandparents are really freaked out by this issue. And so it's really a cool thing to look at the evolution of attitudes and the evolution of issues and how things change over time. And then finally, I mentioned in the first little presentation the idea that we study political phenomena is one of the ways that we do it. The devil is in the details. Basically, often the sources of big political conflicts are mundane. This is simply two guys who wanted their married spouse's name on a death certificate. And they have forever changed the doctrine of the United States. So it's really kind of cool. This sort of, it's almost like chaos theory for those of you who know chaos theory. If a butterfly sort of flutters in China, could that cause a dramatic effect in the weather here? And the answer in this case is yeah, it very well could. And so that's why it's another important thing. I apologize for the length of this, and I hope it's useful. But we finally got to it, so I'm glad to do it, and I'll see you soon.